Have the new ERISA regulations changed the way that disability insurance carriers look at favorable Social Security decisions? There is a U.S. Supreme Court decision that addresses how a disability carrier is to look at and evaluate a favorable Social Security decision. And of course, there are ERISA regulations that also address this as a supplement. I will tell you, as a matter of course, it really doesn't matter what the U.S. Supreme Court has said or the ERISA regulations say, because I find that many times ERISA disability policies or plans will just simply ignore a favorable decision. They won't get the claims file, the Social Security claims file, to understand the basis of the decision. More often what they'll do is they'll say, hey, the standard of disability is completely different. In an ERISA case, the question is, are you unable to do the material and substantial duties of your own occupation or any occupation? But in a Social Security case, your age is a factor. The question is, in a Social Security case, can you do other work in the mythical, hypothetical, not real world national economy in view of your age, education, skills, and your restrictions and limitations? And by the way, age is not a factor in our disability determination because it's not part of the definition of disability. So too bad, so sad. Now, there are many times in which the disability carrier will also say, hey, Social Security didn't have the benefit of our liar for hire peer-reviewed doctor. Their medical records aren't current. When we see a claim that has been denied or terminated based on ignoring a favorable decision, we go on the attack. What do? Well, hopefully I've represented you in your Social Security disability claim, or hopefully your ERISA disability attorney can get your Social Security disability file from your Social Security attorney. We want to submit that because there's a wealth of information in that file, including the decision, hopefully, of a judge. And the judge will have reviewed your eligibility for benefits, addressed your ability to do your past work, and addressed your ability to do other work. Hopefully, your physicians have submitted favorable residual functional capacity forms, and the judge has accepted those opinions and set forth their reasoning as to why you're entitled to your Social Security disability benefits. It's crucial that that documentation be supplied as a way to rebut the disability carrier's denial of a claim and ignoring a favorable Social Security decision. If you have any questions about your rights to your disability benefits, contact us today at 727-894-3188 for a complimentary consultation. We can help you regardless of where you live in the United States, regardless of the nature of your disability, regardless of the carrier. But remember, you only have 180 days in which to file an appeal. That's the trial of your case, and if you blow that deadline, you can potentially kill your case. 727-894-3188.